who were directly appointed from the bar to the Supreme Court and elevated. So I think you will agree that there has been a discrimination in Article 217 itself and Article 124. And I wish to know your opinion on the subject. I have another question as well. May I put it?
May I just answer this? The first thing I want to mention is that it is a matter of sadness and regret that we have not exercised the power of appointment of jurists to the Supreme Court. I can tell you that at least 6 of the professors of law who taught me, each one of them was such a resplendent academic that he would deserve to be appointed as a judge of the Supreme Court. I was taught by Professor Upendra Bakshi. I was taught by Professor P.K. Tripathi. I was taught by Professor D.K. Singh. I was taught by Dr. Lutika Sarkar. I mean, every one of them was actually capable of being appointed as a judge of the Supreme Court. The reason, I think, why the academics were not appointed, and I'm sorry to say that, is a certain fear or a certain insecurity which even judges experience with very strong intellectuals. And I wish to say quite openly, I cannot imagine any reason relating to flaws of character in any of these persons. I don't think you will see a second Dr. Lutika Sarkar. Lutika Sarkar, incidentally, was selected as a teacher of the Delhi University by none other than Bijan Kumar Mukherjee. The day she was selected, Dr. Bijan Mukherjee asked her to take his car and go to the university and join the law faculty. That is the caliber of professors and law teachers, and they're not only in the Delhi University, all over, in Calcutta, in Madras, everywhere. And I think it has been a singular lapse on the part of the Supreme Court, because you need to widen horizons, and academics are capable of widening horizons. At one point of time, Justice A.P. Sen recommended the name of Mr. A.G. Nurani, whose articles you must have read in the Statesman, to be appointed as a jurist directly to the Supreme Court. But when they approached Mr. A.G. Nurani, he said that I dye my hair and I'm perhaps disqualified because I am not that age. So academics, I think, ought to be appointed. And now I think the field is wide open. It should be encouraged. In the United Kingdom Supreme Court, the appointment of Baroness Hale, who's an academic, has been an outstanding appointment. And you can see that she is completely, her views are different, her way of looking at subjects is different, and she is quite open and blunt about the fact that, that her fellow judges and she don't see eye to eye on many matters. But that is where I think a certain kind of diversity is needed in judicial appointments. As far as the absence of this provision in the High Courts is concerned, I think that avenue should be opened up by way of a constitutional amendment. Would you like to give a chance to a couple of other people behind you? And I'll certainly ask you also.
Sir, I would like to thank you and also to other professors and the teachers of our department for conducting that kind of prestigious lectures on the separation of powers, independence of the judiciary. Sir, I would like to know from you that how far is the legislature bound by the judicial decision of the judiciary?
Under our constitution, there is a special provision which does not exist in any other constitution, which is Article 144. Under Article 144, all authorities of the state have to implement the judgments of the court. And we must understand it is because of the binding nature of judicial pronouncements that you still have the rule of law alive in this country. If judgments can be defeated, I think it will be a sad day. Of course, many legislators are not happy about judgments. For instance, when a judgment said that if you are convicted, you stand disqualified for being a legislator, you found that everybody went up in arms. And there was absolute unanimity in the political community, barring a few odd politicians, but otherwise they were quite unanimous. At that time, the hand and the lotus merged, because they all said that it doesn't matter. Convicted people must be given a chance to establish, under the law of presumption of innocence, they must exhaust all their appeals, which meant that they could be for 15 years a legislator until their innocence got established. But this intolerance to judicial verdicts is completely misplaced, and it shows a certain lack of understanding of democratic institutions. I want to give you one example of a prime minister, and I hope one day when the governmental records are put in the public domain, you will have an opportunity to see how some heads of government have conducted affairs of the state. When Prime Minister Morarji Desai took over as the Prime Minister, he called on the then Chief Justice of India, Mr. Justice Beg, and he asked the then Chief Justice of India that, Mr. Chief Justice, would you please let me know, in your considered view, who is the person who can hold the office of an Attorney General for India? Mr. Beg was surprised because he was a judge who superseded Justice Khanna, and this was a new Prime Minister. He was not obliged to consult the Chief Justice, but Prime Minister Morarji Desai knew this because he was a Chief Minister of Bombay, and he knew what was the convention when you appointed the highest law officer in the country. Mr. Beg said, in my view, it is Mr. S.V. Gupte who should adorn the office. And the Prime Minister asked the Chief Justice to invite Mr. Gupte to be Attorney General at the instance of the government. That is how the Attorney General was appointed. So we have to bear in mind that democratic institutions have to give space and respect for each other. If you give respect, even for a judge who has made a mistake in a judgment, you will find that same judge may blossom and may suddenly show a mettle which you thought he never had. So this is a process of dynamism which we must recognize is inherent in the judicial character. And if Justice Beg could appoint and suggest Mr. Gupte, if he could suggest the name of Justice Pulzapukka, Justice Chinappa Reddy, Justice A.P. Sen, Justice Venkatramaya, the judges who held against the government, it should tell you. And at that time, there was no question of primacy of the Chief Justice. This was Mr. Beg's personal assessment. This should tell you exactly what can happen with an independent judiciary. So it's important that we have to free judges also from some kind of oppressive overlay or cloud, and that's very necessary. And that can be done only with the assistance of the legal profession, the academics, and the law students. In my view, the law students are really a part of the legal profession in their infancy, and they are great sources of inspiration. I have never forgotten that how a law student, who was an LLM student, wrote an article on the powers of judicial review under the Constitution. And I want to tell you how judges of the Supreme Court admire that young law student and his article that they sent for him and asked him to have a cup of tea with them in their chambers. He was an LLM student, but they were so impressed with his writing. That is the humility of the judiciary. And it is a process of mutual discourse. But the moment you think you have power and authority in your office, remember, learning stops. And learning should never stop for a judge or a lawyer. Yes. Please come. Sure. This young lady to your right, Dr. Calcutta, yes.
Sir, thank you so much for enlightening us with such wonderful speech. It's indeed an honor that you're present here. So my question is, do you think that now that the Lokpal Bill has been passed, it will ease the pressure of the Supreme Court in existing cases that can be fast-tracked? And another question is, don't you think that there must be more regulations governing the parliamentarians, because ultimately they are the ones who pass laws. So when we speak of separation of powers and independence of judiciary, the people who actually pass laws, that is the legislature, the parliamentarians. So who can be that? Like, what mechanism can be there which can control the legislators so that independence of judiciary can be actually enforced? Because ultimately they are the ones who pass laws.
In my view, as far as the democratic process is concerned, and it's a very, very relevant question which you have asked in the present day context, I think that the vote must be what is called a multifactorial vote. In other words, you have to actually make every voter's mind apply himself to 5 or 6 questions. One of which questions is whether the candidate ever met you. And if that question is honestly answered, and mind you, psychologists have found out that even if you have a bias or a commitment to a political party, the moment you look at multiple questions to answer for a vote, you become freed of that bias. So I think the Election Commission must consider what I think is a multifactorial vote. Up to one point of time, you remember that this no vote was never recognized, and it was a great debate when Shiv Khera went in a writ petition in the Supreme Court. I remember I appeared for him, and the judges simply flung the paper book and said that, well, we can't change the law, but today you have a no vote too, or a negative vote. And similarly, I think you should have a multifactorial vote. It will definitely improve the quality of the voting process itself and will ensure greater accountability. It's a very good question.
Thank you so much, sir. The question along from your team is horse-struggling. This is brilliant. Thank you so much, sir.
Thank you. Oh yes, go ahead.
Sir, I just want to ask you, what are your comments about the role of the media and the media trials which take place on television? Do they influence what happens inside the court? If yes, then why are not the courts are stopping it?
Personally speaking, I think the media has, on occasions, have subserved the cause of justice in a very important way. Sometimes I find that the media carries a story without adequate verification. Both instances happen. But I would still say that on the balance of freedom of expression and freedom in a democratic society, it is safer even to give the media the latitude of error. I say this with a certain measure of consideration. In a case which I know, which was a murder case, the Jessica Lal case, if it was not for the media, the accused may have got off. It was a vigilant media which kept public opinion and pressure on a prosecutor to do his duty. So sometimes the media plays a very vital role even in the administration of justice. Its value cannot be undermined. But at the same time, it is necessary that they must be cautious when they report about events, about persons, about proceedings in court. But when you are a lawyer, you will realize that the strength sometimes of law is not in your personal feelings. The strength is sometimes in the mere space you give something like the Fourth Estate. Thank you.
Thank you, sir. Thank you very much.
No more questions. No.
Just a couple of more questions then. I don't want anybody to feel disappointed. I don't want anyone to feel yes. I would like to answer all questions.
Please ask 3 questions together so that we don't take too much of the generosity.
I'm here. I'm not leaving until I answer your questions. And I'm absolutely impressed with your questions. So please ask as many.
So, we are thankful to have you, and you gave us such a nice lecture on independence of judiciary. So, I am asking you the question that sometimes we see that in a lower court, the judge gives a wrong verdict, sometimes becoming biased. It often extends to lifetime or capital punishment. But when it comes to the higher court, the judgment of the inferior court is overruled, and they are free from the punishment. The person who were punished were free from the punishment. But up to that, the victim has to suffer a lot. He has to remain in prison also. The lower court judge would not be penalized for the wrong he had done to a simple person having no fault. Is it just because of his power?
This is a very good question, and I want to give you a very accurate answer. Unfortunately, the subordinate judiciary in our country has been also pulverized in some way, that they prefer to convict rather than acquit. It is much easier to convict. It is more difficult to acquit. And no judge wants to take the risk of being misunderstood in acquittal. You see, we must understand that trial courts are functioning under an umbrella of supervision. But the Supreme Court has held that the administrative control of high courts is only for the purpose of administration. It can never be for the purpose of overseeing judicial functions. So, the National Judicial Academy, the state judicial academies have taken up this issue with many judges belonging to the subordinate judiciary. And as I said, one day there will have to be an equivalence in caliber of the trial court, high court and the Supreme Court. That day is not far off, but that is the way in which the aspirations of justice in India